From the Supreme Court to high courts across the country, this is where India's biggest legal developments come into focus. You're listening to LiveLaw Daily, your quick, sharp, and reliable breakdown of the stories shaping the law, the courts, and the Constitution. I'm your host Debojit Das, and here are today's top legal headlines. Today's Supreme Court ruling on bail under the UAPA Act could have major implications for two of the country's most closely watched cases, those involving Umar Khalid and Sharjeel Imam in Delhi Riot's larger conspiracy case. A bench of Justices B.V. Nagratna and Ujjal Bhuyan granted bail to Syed Iftikhar Andrabi, who has spent more than 5 years in custody in a narco-terror case under the UAPA. But the bigger development came from court's sharp observations on the Delhi High Court judgment in Gulfasha Fatima, the same ruling that denied bail to Umar Khalid and Sharjeel Imam. The Supreme Court said that judgment failed to properly apply the three-judge bench ruling in K. Najeeb, which had clearly held that prolonged incarceration and delays in trial can justify bail even under the strict provisions of the UAPA. The court also highlighted how harsh Section 43D5 of the UAPA is. This provision effectively makes bail extremely difficult by requiring courts to deny bail if the accusations merely appear believable. Referring to the NCRB data placed before the Parliament, the bench noted that UAPA conviction rates nationally range between only 2 to 6%, and in Jammu and Kashmir, less than 1%. The court observed that these figures point to a high probability of acquittal at the end of trial. The bench made its position clear, stating that a smaller bench cannot ignore the law laid down by a larger bench. And for our second story here, we have West Bengal's political transition in focus that continues to spill into the courtroom. In the latest development, the Calcutta High Court has allowed Trinamool Congress leader Jahangir Khan to contest the Falta repoll scheduled for May 21st, while also directing that no coercive action be taken against him in pending FIRs till May 26th. Khan approached the High Court after multiple criminal cases were registered against him following the May 4th election results. Appearing for Khan, senior advocate Kishore Datta argued that the timing of the cases was impossible to ignore. He told the court, after May 4th, everything changed. A series of cases has been lodged against him in just a few days. I cannot even go there as a candidate. Justice Saugat Bhattacharya also noted that FIRs appear to have been filed from May 5th onwards, immediately after the political developments in the state. The court observed that there had clearly been a change in political circumstances and the timing raised questions. On the other side, the Deputy Solicitor General argued that the allegations involved booth capturing and voter intimidation during the earlier Falta poll, which had itself been cancelled over malpractice allegations. He claimed that BJP ballot buttons in several booths had been covered with black tape. But when the court asked whether it could conclusively assume Khan was responsible, the response was, it has to be assumed. The court was not convinced with this answer, as it said Khan should cooperate with the investigation but also be allowed to contest these elections. As the court put it, after all, this is a democratic country, let the democratic spirit be upheld. And for our third story here, the Delhi police has opposed Umar Khalid's plea for interim bail in the larger conspiracy case linked to the 2020 Northeast Delhi riots. Khalid had sought temporary release for 15 days, from May 22nd to June 5th, to attend the Chehlam ritual connected to the husband of his maternal aunt and to help care for his mother, whose surgery is scheduled for June 2nd. But in its reply before the Delhi court, the police argued that Khalid's release could affect public order given the sensitivity and wider ramifications of the case. The prosecution said the plea lacked any exceptional or urgent grounds that would justify interim bail. The police also questioned the basis of the religious ground raised by Khalid. It pointed out that Khalid had not shown any compulsory religious obligation that specifically required his presence here. Importantly, the Delhi police also told the court that family arrangements are already being handled by Khalid's father and other relatives. Khalid is an accused in an FIR from 2020, which includes charges under the UAPA, the Arms Act, the Prevention of Damage to Public Property Act, and several provisions of the Indian Penal Code. And our fourth story is from the Supreme Court, which has stepped in to halt further counting in the Bar Council of Delhi elections after serious allegations of irregularities surfaced during the counting process. The controversy reached the court on an urgent basis, where senior advocate Shobha Gupta alleged that even tampered ballot papers were being counted. Telling the bench that there's an emergency, she sought immediate intervention from the court. Taking note of the seriousness of the allegations, the Supreme Court observed that resolving the dispute would require a detailed examination of original election records, including the ballot papers themselves. The bench therefore held that the Delhi High Court would be appropriate forum to examine the matter in depth. So the Supreme Court has now transferred all petitions related to the Bar Council elections to the Delhi High Court and requested the Chief Justice there to constitute a special bench within this week to hear the matter. Until then, the election process has been frozen at its current stage, with counting staying suspended. And in another significant development in the same story, the court also referred to a confidential letter sent by former Delhi High Court Judge Justice Talwant Singh. While the contents of the letter were not disclosed in open court, the Supreme Court stated that it had examined the communication and directed that it be resealed and forwarded to the Chief Justice of the Delhi High Court for necessary action. And for our fifth story, a Gurgaon court has sent Punjab Minister and AAP leader Sanjeev Arora to judicial custody till June 1st in a money laundering case being investigated by the Enforcement Directorate. Arora's ED custody was ending on May 18th, after which the agency sought that he be remanded to judicial custody while the investigation continues. Arora had been accused in an alleged 100 crore GST fraud linked to a company he had previously headed. He has already approached the Punjab and Haryana High Court challenging his arrest under the Prevention of Money Laundering Act or PMLA. In his plea, Arora has sought quashing of the arrest, the grounds of arrest and the remand order, alleging violations of both statutory safeguards and his fundamental rights. Before the Gurgaon court, Special Counsel for the ED, Zohaib Hussain, argued that there was a risk of evidence tampering and possible influence over witnesses who have been summoned in this case. According to the ED, this made judicial custody necessary while the probe remains ongoing. The agency also told the court that under Section 187 subsection 2 of the BNSS, it reserves the right to seek further custody of Arora within permissible 40-day period from the date of arrest, if required later in the investigation too. The court, while allowing judicial custody, also directed jail authorities to ensure that Arora receives all prescribed medicines in accordance with medical rules. And for our second last story, we go to the Kerala High Court, which has said that governments have a responsibility to properly inform transgender persons about fertility preservation options, like preserving sperm or oocytes, before they begin gender reassignment treatment. The judge in the case observed that many transgender persons may permanently lose their ability to have biological children after treatment, making awareness and counseling extremely important. The court also pulled up the government for failing to frame proper medical guidelines even 6 years after the Transgender Persons Act came into force. It noted that although a standard operating procedure exists, no comprehensive health manual or formal guidelines have been issued for sex reassignment procedures in line with international standards such as WPATH guidelines. The court said that this lack of action has effectively left transgender persons in peril. The observations came while hearing a plea filed by a transgender man, a person assigned female at birth who now identifies as male, seeking permission to cryopreserve oocytes before undergoing further gender transition treatment. The petitioner had also challenged a provision of the Assisted Reproductive Technology Regulation Act, which limits ART services to women between 21 and 50 years and men between 21 and 55 years. And for a last story today, the Central Information Commission has ruled that the BCCI is not a public authority under the Right to Information Act, meaning it cannot be forced to disclose information under the RTI law. The order was passed by Information Commissioner PR Ramesh while dismissing an appeal filed by Delhi resident Geeta Rani. The case began with an RTI application filed before the Ministry of Youth Affairs and Sports in 2017. The applicant wanted to know under what legal authority the BCCI represents India internationally, selects players for the national team, and why governments provide infrastructure and security for cricket matches. The ministry replied that it did not have this information and could not transfer the application to the BCCI because the cricket board had not declared itself a public authority under the RTI Act. Interestingly, in 2018, the CIC had taken the opposite view and directed the BCCI to comply with RTI obligations. But that order was challenged before the Madras High Court, which later sent the matter back to the CIC for reconsideration. Now, after re-examining the issue, the Commission has held that the BCCI does not meet the legal definition of a public authority. It said the BCCI is simply a society registered under the Tamil Nadu Societies Registration Act and not an entity created by the Constitution, the Parliament, or even the government notification. The CIC also noted that while the BCCI performs important public functions, that alone is not enough under the RTI Act. Since the board is neither substantially controlled nor financed by the government, the appeal was dismissed. And that's a wrap on today's edition of LiveLaw Daily. For full reports, courtroom updates, and everything happening in the world of law, visit livelaw.in. We'll be back tomorrow with more stories from the courts that matter.